This program is brought to you by Emory University.
Good afternoon. We're going to get started with the second panel. The second panel is called Voters' Rights, Voter Access and Requirements, and it'll be moderated by Professor Alexander Sasha Volek. Professor Volek is an assistant professor of law and joined the Emory Law faculty in the fall of 2009. Professor Volek earned his Bachelor's of Science from UCLA and his JD and PhD in economics from Harvard University. He clerked for Judge Alex Kaczynski of the Ninth Circuit and for Supreme Court Justices Sandra Day O'Connor and Samuel Alito. Before coming to Emory, he was a visiting associate professor at Georgetown University Law Center and a visiting assistant professor at the University of Houston Law Center. His interests include law and economics, administrative law, and the regulatory process. Please join me in welcoming Professor Volek.
Thank you, Will. So our first speaker is Andrea Young, who is the Executive Director of the ACLU of Georgia. Andrea Young joined the ACLU of Georgia as Executive Director in 2017. Under her leadership, the organization has grown in influence, impact, and membership, battling injustice through the courts, legislative advocacy, and community engagement. Voter rights is an affiliate priority through 2022. Young, as an attorney, nonprofit leader, and author, has devoted her career to promoting policies to defend and extend civil and human rights. Prior to joining the ACLU, she taught leadership and social policy at Georgia State University, was the founding executive director of the Andrew Young Foundation, and created the Making of Modern Atlanta project that included an archive, documentary film, and book. She has worked as a congressional and Senate aide and nonprofit leader to end apartheid in South Africa, established the Martin Luther King holiday, expanded support for working families, expanded access to reproductive health care, and expanded access to early childhood education. Young has received numerous awards for her work, most recently from the YWCA of Metropolitan Atlanta, the Georgia Association of Black Women Attorneys, and the Islamic Speakers Bureau. She is a founding board member of the National Center for Civil and Human Rights. Young is a member of the State Bar of Georgia, a graduate of Swarthmore College, and received her law degree from Georgetown University School of Law.
Well, great. It's great to be here, and really pleased that that you all have decided to really focus on voting rights as an issue at this very important symposium. And I've been taking great notes. I really think all of us here are getting enriched. Those of us on the panels are also really being enriched by being here with you. A lot of time, there is a, saying when the law's on your side, argue the law. When the facts are on your side, argue the facts. And I want to put a lot of this discussion in context, because I know particularly we have a lot of young people for whom the context in which we are even addressing voting rights is something of, an abstraction. And so for me, it's not an abstraction. I'm really indebted to Professor Woods for pointing out that Donald Trump's donors are to the right of David Duke, because that is my first encounter with the voting rights issue. I grew up in Thomasville, Georgia, which is as far south as you can go without being in Florida. And Dwight Eisenhower was running for president, so this was quite a long time ago, 1956. And my dad was a pastor of the small church that you see, a church founded in 1891 in Thomasville, Georgia, and a church where African-American congregation was still trying to access the right to vote. And so my dad was encouraged to register black voters in Thomas County, and the response to his voter registration efforts was a Klan rally. And so what I learned early on as a toddler about voting rights is that they are very important and that exercising them is very dangerous. So despite the 15th Amendment, poll taxes, literacy tests, and other bureaucratic restrictions were used to deny African Americans in the South the right to vote. They also risked harassment, intimidation, economic reprisals, and physical violence. And so that is the context for voting. If we're going to talk about voting rights in the South, that's the context in which all of this debate, all of this takes place. So fast forward to 1965, following the passage of the Civil Rights Act that desegregated public accommodations, there was an effort, again, to extend voting rights. Amelia Boynton brings Dr. King to Selma. C.T. Vivian is turned back on the courthouse steps by the sheriff and deputies. On Sunday, March 7th, the first attempt at a march from Selma to Montgomery, John Lewis, Amelia Boynton, and others are beaten severely by law enforcement officers acting in their official capacity. Jimmy Lee Jackson, a veteran and a citizen of my mother's hometown of Marion, Alabama, is killed for his voter registration activities. James Reeb, a Unitarian minister who comes to support the efforts, is also beaten to death. Viola Uzo, a mother and homemaker, white woman from Detroit, is killed, also working to help the Selma March. Thanks to a court order from Federal District Court Judge Frank Johnson, a multiracial group marches from Selma to Montgomery. This photo is from the first day. I was in the crowd, and you can see my mother in the second row behind, her face shows up between Ralph Bunche, who was then the Deputy Secretary General of the United Nations, and Juanita Abernathy. This was March. By August, Lyndon Johnson had signed the Voting Rights Act, August 6, 1965. Key provisions gave the Attorney General authority to be proactive in enforcing the right to vote, including sending federal registrars to the South. Literacy tests were outlawed, other bureaucratic means of limiting access to the vote by people based on race, and a category of communities was established that had to submit their voting changes to the Justice Department for pre-clearance. How did this personally and for Georgia? Some of you know John Lewis is currently our representative from the 5th Congressional District. But in 1970, my dad runs for Congress because of the Voting Rights Act, wins a Democratic primary, and loses the general election. In 1971, the Georgia General Assembly has redistricting and draws him out of the 5th Congressional District. So ironically, the line was drawn near a wall that had been erected in 1965 to keep blacks out of the very neighborhood where my dad then lived and still lives today. And the ACLU, Lachlan McDonald, challenged that plan under pre-clearance. So because of Section 5 of the Voting Rights Act, the pre-clearance requirement, the ACLU was able to submit an administrative challenge to the line drawing, and the result was that the decision was reversed, and Young became the first African American elected to Congress from the Deep South since Reconstruction. So why do we say it that way? Because during Reconstruction, African Americans served in the Congress from the South. There were as many as, until 1908, there were as many as 58 African Americans that served in the Georgia legislature. But the Supreme Court undermined the provisions and the enforcement of the 15th Amendment, the Civil Rights Act that were passed after the Civil War, so that we had this long gap between 1908 in terms of even the State House service between 1908 and I think 1962 when Leroy Johnson was elected. Tremendous progress happens with this velocity from the Voting Rights Act. Maynard Jackson becomes the first black mayor of a major southern city. The Georgia Black Legislative Caucus was established in 1975. It's now the largest in the country. The motor voter bill you heard referenced passed in 1993 under Bill Clinton. I had the privilege of working on that. The Voting Rights Act and its pre-clearance requirements are reauthorized in 75, in 82, in 2006. The number of black members of Congress in Georgia alone expands to 4 by 2003. And in 2005, Georgia issues a strict government-issued photo ID requirement for voters in Georgia. In 2006, the House and Senate passed and George Bush signed reauthorization of the Voting Rights Act for another 25 years. And Barack Obama is elected president of the United States. In 2013, we had Shelby B. Holder. The Supreme Court guts the Voting Rights Act. Obviously, I don't think these two slides I don't think this is a coincidence. Justice Roberts wrote, quote, "A statute's current burdens must be justified by current needs." And voter registration and turnout numbers in the covered states have risen dramatically in the years since. Racial disparity in those numbers was compelling evidence to justify the preclearance remedy and coverage formula. There's no longer a need for such a formula. Justice Ginsburg, however, said, quote, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory change is like throwing away your umbrella in a rainstorm because you are not getting wet." And that certainly has proved to be the case, that in the absence of preclearance, we see a torrent of measures to restrict voting, restricting voting days and hours, trying to make voters re-register when they move, even within the state, closing polls, packing black voters into districts, cracking black voters into many districts, minority vote dilution, the case that Brian was talking about in Americus, Georgia, reverting to at-large districts, using the redistricting process to dilute urban districts like Fulton and DeKalb. So this image is from Randolph County. One of the things just ahead of the 2018 election, we got word from an activist in Randolph County that there was a plan to close 7 of the 9 polling places. We organized with the ACLU, with NAACP, with New Voter Project, all the groups that are on the ground trying to do voter registration and voter mobilization to alert the media, to pack the courthouse. We did canvassing door to door because in Georgia there's a provision where if enough people in a precinct sign a petition, it'll reverse the poll closure. It was a massive effort that took place over about 5 weeks. And the result was that we won and we reversed those poll closings. However, if we had had preclearance, we could have done it with a letter. And so this took an incredible mobilization of resources, of people on the ground, of ordinary people in Randolph County coming out to hearings, an incredible mobilization of effort to accomplish something that under preclearance we could have done with a demand letter to the Justice Department. And so this has been the work since I've been at the ACLU since 2017, almost immediately, working to push back efforts to limit access to the franchise. We've secured a number of reforms in the legislature. We've reopened some of the polling places. We've led a coalition to stop a bill that would have eliminated Sunday voting in Georgia, cut back on the Souls to the Polls program. In North Carolina, for example, the Sunday voting is almost 90% utilized by African American voters. One of these voter purge cases, we were able to get 160,000 restored to the polls because they had been done, to the rolls, because the purging had been done in violation of the state's own law and practice. And then as you heard, that was, thank you, Brian, that was our case in Gwinnett County, addressing the signature match issue. So on numerous very minute areas of the law, very specific areas of, if you want to push lower income young people off the rolls, then you do the purging. So every 3 or 4 years, young people move a lot. Poor people, particularly in Metro Atlanta, move a lot because they're chasing affordable rent. So if you want to keep them off the rolls, then you do these regular purgings. If you want to get at the super voter, the moderate income, middle class homeowner, you change their polling place. So everything in the voter suppression toolkit has been at work in Georgia. And it's important that we understand the role that facts play. There's a big discussion about what is an undue burden. Well, an undue burden to someone who drove here today, in a car, and could afford the parking lot is one calculation. But an undue burden to someone who takes the bus, who works an hourly job and has to punch a time clock, who has 2 kids that they have to pick up from daycare or they'll be charged for that, is a very different kind of calculation. And so we have to make and explain to the courts what are the facts that really are behind these voter suppression. Why is it voter suppression? Why is it an undue burden? And we see this not only in the Voting Rights Act, but also I do reproductive health, and so we see it in the reproductive health. What is an undue burden? An undue burden for a working mom with 2 kids is a very different calculation. And so we have to make sure that as advocates, we're telling the stories of our clients. We're making sure that the truth of people's lives is being reflected in the kind of decisions that are being made about voter access. So my vision of a voter, because when my dad ran for Congress, I was in high school, and so of course I had no choice but to actually go out and campaign. And one of the first things we would do is before school, I had to go out with him to the bus stops, because in Atlanta, working class black women were at the bus stops at 6:30 and 7 o'clock in order to go to work. And so my vision of a voter is that person who is at the bus stop at 6:30, 7 o'clock in the morning, going to a minimum wage job, an hourly job, where if they miss an hour of work, they miss that paycheck. They miss that hour of pay. And so my vision of what is voter access is cued to those people. And I think it's very important that we keep that in mind when we talk about what is voter access and what is voter access in the South, and how subtle voter suppression can be given that context, how effective very subtle so-called regulatory, so-called we're just getting at fraud measures can be in suppressing the vote of hardworking Americans who have tremendous burdens, who are traveling by public transportation, who are working an hourly job, and who need the right to be heard and have influence in this democracy. And so that's what we do at the ACLU of Georgia, and our focus will, not surprisingly, be redistricting reform, but also to stop voter suppression in all its forms and expand access to the ballot. Because if we are a democracy, then every citizen should be able to vote every time and have their vote count the same as every other voter. Thank you.
Thank you, Andrea. Our next speaker is Gary Simpson, who's the Macon Chair in Law at Mercer University School of Law. Gary Simpson holds the Macon, he's also a professor emeritus of law at Cornell Law School. Simpson received a BA summa cum laude from Yale College, where he majored in Spanish literature and was elected to Phi Beta Kappa, and a JD from Yale Law School, where he was an editor of the Yale Law Journal. After clerking for Judge J. Joseph Smith of the Second Circuit, Simpson began his teaching career at University of Texas School of Law. Simpson joined the Cornell Law School faculty as professor of law in 1980 and remained at Cornell until 2006, serving as Associate Dean for Faculty Development from 1997 to 2000 and as Associate Dean for Academic Affairs from 2000 to 2004. In 2006, he became Dean and Joseph C. Hostetler Baker and Hostetler Professor of Law at Case Western Reserve University School of Law. He left Case in 2010 to become Dean of the School of Law and Macon Chair in Law at Mercer. He served as Dean until being appointed in 2014 to Senior Vice Provost for Faculty Scholarship in the Central University. In 2018, he returned to full-time teaching. Over the years, Simpson has taught constitutional law, conflict of laws, religious liberty clinic, statutory law and analysis, and seminars on freedom of religion and other constitutional law topics. His constitutional law scholarship has addressed such issues as school vouchers, Supreme Court appointments, same-sex marriage, the death penalty in religion, and single-sex schools. He is also the author of a leading conflict of laws casebook and various articles in the field.
So my topic's going to be the implications for voting rights of giving disproportionate racial impact the constitutional importance it deserves. So I'm going to talk about a few constitutional law cases in two decisions in the mid-1970s, Washington against Davis and Village of Arlington Heights against Metropolitan Housing Development Corporation. The Supreme Court made clear that proving that a law racially neutral on its face disproportionately disadvantages racial minorities doesn't establish a violation of the Equal Protection Clause or even create a presumption that such a violation has occurred. The key, according to the court, lies in proving that the law was the product of a racially discriminatory purpose. My focus today will be the inadequacy of that approach. It's an approach that has importance for a wide variety of laws, not only laws dealing with elections, but that warrants discussion in this symposium because its effect on the field of election law is especially profound. It wrongly gives a reprieve to voter ID laws, purges of voters from registration rolls, and other legal barriers to voting that, though framed in terms that don't mention race, disproportionately disadvantage racial minorities. As the United States Commission on Civil Rights documented in a 2018 report, recent years have seen an increase in the variety and number of legal impediments to voting that disproportionately disadvantage racial minorities. Also, according to that report, the justifications commonly offered in defense of those barriers disproportionately disadvantage racial minorities. Those barriers, those reasons tend to be exceptionally weak. After unanimously finding that racial discrimination in voting has proven to be a particularly pernicious and enduring American problem, the Commission underlined the wide range of state-created impediments that have perpetuated that problem. The Commission wrote, in states across the country, measures that wrongly prevent some citizens from voting have been enacted and have a disparate impact on voters of color and poor citizens, including but not limited to voter ID laws, voter roll purges, proof of citizenship measures, challenges to voter eligibility, and polling place moves or closings. So first, I'm going to speak very briefly about the lessons of Davis and Arlington Heights. I will then argue that from the start, Davis and Arlington Heights, the approach that they articulate, posted very little threat of invalidation to laws disproportionately disadvantaging racial minorities. The only laws really threatened by the approach are ones very much at the extreme, patently and unmistakably the product of bias against racial minorities. There's a lot more that can be said about Davis and Arlington Heights than I'm going to try to say today, because I want to get to the part of my talk that really I think is distinctive. So I'm going to argue that the approach in Davis and Arlington Heights wrongly assumes, wrongly ignores basic assumptions about the lawmaking process that help explain why the Supreme Court has treated as suspect laws explicitly disadvantaging racial minorities. I'll propose an alternative approach that gives disproportionate racial impact the importance that I think it deserves under the Equal Protection Clause, and then I'll discuss the implications of adopting that approach for legal impediments to voting. So to start with Davis and Arlington Heights, I think it's important to give a little backdrop in the form of a decision that came a few years earlier in 1971, Palmer against Thompson. Faced with a judgment declaring that it was violating the Equal Protection Clause by maintaining racially segregated public swimming pools, the city of Jackson, Mississippi, closed all the pools. That case came up to the Supreme Court. All the justices seemed agreed that the case turned on the city's purpose in closing the pools, but they very much disagreed as to what the purpose should be understood to be. From the perspective of Justice White, who authored the principal dissent, the city's claim that it had closed the pools out of concern that if integrated, the pools couldn't be operated safely and economically was not even, Justice White said, colorable. In his view, the city's purpose in closing the pools was, quote, solely to circumvent the desegregation order. Quote, whites feel nothing but disappointment and perhaps anger at the loss of the facilities, White wrote. Negroes feel that and more. They are stigmatized by official implementation of a policy that the 14th Amendment condemns as illegal. The majority opinion by Justice Black took a very different view of the city's purpose. As Black saw it, the dissents claimed that the city's stated purpose was a pretext and that the city instead had acted on the basis of an invidious purpose of avoiding mixing of the races was simply out of bounds. According to Black, no case in this court has held that a legislative act may violate equal protection solely because of the motivations of the people who voted for it. And he made clear he wasn't about to start striking down laws on that basis in Palmer. The Davis case came 5 years later, was an equal protection challenge to a DC Police Department's use of a written qualifying exam that had the effect of screening out a much higher proportion of Black applicants for the police force than white applicants. White made clear that a law having a disproportionate racial impact may be successfully challenged under the Equal Protection Clause if the challenger can prove that the impact can, quote, ultimately be traced to a racially discriminatory purpose. Without explicitly saying so, he was basically overruling Palmer against Thompson. White denied that the disproportionate racial impact, though, had any constitutional importance other than as possible evidence of a discriminatory purpose. The appellate court had expressly indicated that it was proceeding on the assumption that in the constitutional realm, it should apply the approach to disproportionate racial impact that the court had applied in 1971 in Griggs against Duke Power. Griggs had interpreted Title VII of the 1964 Civil Rights Act as making presumptively invalid any, quote, tests or criteria for employment or promotion, quote, that disproportionately burden racial minorities. The next case was Arlington Heights, with Justice Powell now writing. Powell conceded that determining whether a lawmaker was motivated by an unconstitutional purpose can frequently be difficult, but he affirmed as a general proposition the feasibility of making sensible determinations of discriminatory purpose by careful inquiry into such, quote, circumstantial and direct evidence of intent as may be available. He went even further and he offered a summary identifying various subjects of proper inquiry to determine whether a racially discriminatory intent existed. The challenged governmental action in Arlington Heights was the village's refusal to rezone a parcel of land to allow the construction of low and moderate income housing that would be expected to increase significantly the percentage of racial minorities in the village. As in Davis, the court in Arlington Heights found that the challengers failed to carry their burden of proving that discriminatory purpose was a motivating factor in the lawmaker's decision. Although Davis and Arlington Heights are the key cases dealing with racially discriminatory impact, a third case from the 1970s, Personnel Administrator of Massachusetts against Feeney, provided very important clarification. Feeney was an equal protection challenge to a law disproportionately disadvantaging women, not racial minorities, but the court made very clear that it regarded Davis and Arlington Heights as the key precedents and was expounding on their meaning. The law challenged in Feeney was a Massachusetts law giving veterans who passed a civil service exam what the court called a, quote, well-nigh absolute advantage, quote, in competing for civil service jobs. At the time of suit, largely as a result of federal laws restricting the number of women who could enlist and the simple fact that women had never been subjected to a military draft, only 1.8% of veterans in Massachusetts were women. In rejecting a motive-based challenge to the law, the court addressed more directly than it had in Davis or Arlington Heights a key question for the inquiry that they framed, and that's what counts as a discriminatory purpose. The court said a discriminatory purpose implies that the decision maker selected or reaffirmed a particular cause of action, at least in part because of, not merely in spite of, its adverse effects upon an identifiable group. It only exists if the adverse effects were desired. So what I want to turn to now is the impact of this approach. And intentionally or not, that approach of Davis and Arlington Heights was destined right from the start to be really all bark, no bite. 4 factors in particular combined to ensure that the approach would be of little importance in practice. First, they set the bar very, very high. Proving a racially discriminatory purpose means proving the lawmaker desired the adverse effects the law has on racial minorities. In thinking about the kind of showing required to prove a racially discriminatory purpose, ask yourself what kind of people act with racially discriminatory purposes. The short answer, thoroughgoing racists, people who get gratification from making racial minorities miserable. Proving that a racially discriminatory purpose was a motivating factor in the lawmaker's decision therefore means showing that a significant proportion of those voting for the law are eminently rotten people. With very rare exception, that's going to be a very steep hill for any challenger to climb. The second factor that I think made this approach pretty toothless is the sensitivity of the charge. It's a big deal for a court to charge a state legislature or any decision maker with enacting the law for the purpose of disadvantaging racial minorities. That's nothing less than accusing them of being wretched individuals who look for legislative opportunities to make the lives of racial minorities miserable. For a court to level a charge like that can't help but have some adverse effects on the lawmaker, and even more so, it can't help but place strain on the relation between the court and the political institutions. Another negative in terms of the practical effect of this test is it sort of provides a blueprint to lawmakers for how to avoid detection. Before Davis, racist lawmakers were more apt to make their racial purposes explicit if doing so would be politically expedient, which unfortunately in many instances it was. Davis and Arlington Heights make clear that racist lawmakers announce their racist purposes at their peril. Forewarned by those cases, racist lawmakers don't have to be especially savvy to recognize that even if it may seem politically expedient to speak openly about racist purposes, their candor would be the law's undoing. Arlington Heights enumerates these various subjects of proper inquiry, and that makes proof harder in its own way. Those relevant subjects of proper inquiry is like a don't-do list for racist lawmakers. So, for example, if you're drafting minutes of meetings and committee reports, keep in mind that they're going to be looked at later for damning history. Finally, lawmakers have become more and more able to camouflage racially discriminatory purposes. They've been able to take advantage of advances in data collection and analysis to craft less obvious, better disguised means of disenfranchising racial minorities or reducing the impact of their votes. Writing in 1994 for a Supreme Court majority, Justice Souter noted, quote, "The demonstrated ingenuity of state and local governments in hobbling minority voting power." Particularly because lawmakers have easier access than challengers to data and analysis regarding the impact of particular changes, the superficially race-neutral barriers that some states and localities have developed are much more difficult to attack than the older, cruder means. If you want to see one of the rare cases in which a discriminatory purpose attack actually wins, look at a Fourth Circuit decision in 2016, North Carolina State Conference of NAACP against McCrory, a voting rights case. It illustrates the high level of unwitting transparency and downright bumbling on the part of lawmakers that's needed for an attack like that to win. Let me then turn to sort of what the approach ought to be. Given the historic national commitment to racial equality reflected in the Equal Protection Clause, racial bias in lawmaking is sufficiently hard to prove under the Davis and Arlington Heights approach that you would at least ought to wonder, does this approach really do justice to the clause? The disproportionate racial impact that the challengers in Davis and Arlington Heights made the centerpiece of their claims had independent importance that the court's very single-minded focus on discriminatory purpose wrongly denied. Under that approach, a law's disproportionate impact on racial minorities can be used to help prove a discriminatory racial purpose, but it has no independent importance in and of itself. If it can't be used successfully to prove discriminatory racial purpose, the impact is really beside the point. Strictly speaking, a law that disproportionately disadvantages racial minorities, of course, isn't a racial classification, and therefore doesn't automatically trigger what the Supreme Court has called strict scrutiny. But I'm going to suggest it needs to be taken a lot more seriously than it is now. If you think about what lawmakers do when they make laws, they classify, they treat people differently in order to serve the legislature's goal. With rare exception, they don't try to serve the goal precisely. To do that would cost more in individualized decision-making than they think the goal is probably worth, or it might give more discretion than they think advisable to a court or other decision-maker vested with enforcing the law. In deciding whether equal protection is met, the courts have long deferred to these legislative realities, and they give lawmakers a great deal of latitude to classify imprecisely, as long as the classification has a rational relationship to the legislator's goal. The court will almost always allow the law to stand. All that really means is if a member of the group disadvantaged by the classification is at all more likely than a member of the group advantaged to contribute to the problem that the law seeks to eliminate, they're going to uphold the law. When the Supreme Court developed the doctrine of suspect classification and recognized racial classifications as suspect, it established a standard of review that turned that deference on its head. The court held that in deciding the constitutionality of a racial classification, courts mustn't be so tolerant of imprecision in classification. It should strike down classifications if the state could have pursued its objective more precisely, and it'll strike them down unless the objective pursued is one of compelling importance. The court has never said definitively what makes a classification suspect, but the two factors that it's treated as most important both seem to derive their importance from their impact on the trustworthiness of the classification process. One factor, the disadvantaged group's relatively limited political power, raises doubts about the fairness and activity of the classification process because with little to lose from unfairly disadvantaging a group, and often with little occasion or incentive to get to know members of that group well, legislators are much more likely than usual to legislate on the basis of unfairly negative stereotypes about that group. The other factor that appears to figure most prominently is the intense societal prejudice against the disadvantaged group. If legislators are apt to form unfair negative stereotypes about a group with relatively limited political power, they're apt to form even more negative stereotypes about a group that many of their constituents and many of themselves regard with animus. So if the essence of courts treating racial classifications as suspect is distrust of the legislative process when lawmakers classify to the disadvantage of racial minorities, a question should arise when lawmakers pass laws that on their face don't classify on the basis of race, but that foreseeably have a disproportionate racial impact. Even if the reasons that spark suspicion of lawmaking when lawmakers explicitly classify on the basis of race may not apply as strongly, don't they continue to apply with substantial force? I believe they do, and respect for the court's recognition long ago that racial classification should be treated as suspect calls upon the Supreme Court to revise its approach and start treating disproportionate racial impact as a matter of independent constitutional importance. Aside from being consistent with sort of Supreme Court suspect classification doctrine, it's also much more psychologically realistic than an approach like Davis and Arlington Heights that insists that disproportionate racial impact is only worth paying attention to if it sheds light on a discriminatory purpose. Racial bias figures into lawmakers' thinking as it may figure into the thinking of other members of society in more subtle but still very troubling ways. Thanks to the literature on implicit bias, it's common knowledge. We all perceive the world through lenses shaped to some extent by preconceived notions of which we're unaware. Some of those preconceived notions may be pretty innocuous, but not preconceived negative notions about members of races other than our own. As a result of implicit bias, a lawmaker weighing a law's costs and benefits may put disadvantages racial minorities in the cost column, but count it as less of a cost than a more objective observer would. Or perhaps the lawmaker would treat disadvantages racial minorities as a matter of indifference, neither a cost nor a benefit. Either way, the lawmaker's racially biased determination needs to be treated as a serious equal protection problem, and that's very much what Washington against Davis and Arlington Heights don't do. My final step, I'm going to take you to a proposed approach and then apply it quickly to voting. So if you think about what the court has done when it calls for strict scrutiny of racial classifications, it said it has very distrustful of the fairness of the legislative process when legislatures engage in comparative generalizations about racial groups and arrive at a result that single out racial minorities for disadvantage. In effect, the court has told courts, assume that legislators acted on the basis of unfair stereotypes unless the state can prove the classification serves the state interest of the highest order as precisely as possible. If a law doesn't classify along racial lines but disproportionately disadvantages racial minorities, it's not as clear that the lawmakers in adopting a law were as aware of its adverse consequences as if they had an explicit racial classification. But what if legislators were aware that a law would have a disproportionate impact on racial minorities and enacted it nonetheless? There, I think there's very good reason to think that in enacting it, they engaged consciously or subconsciously in comparative generalizations about racial groups reflecting unfair stereotypes. Under the circumstances, the usual rational basis approach is not warranted. You need something much more. So I've suggested, and I'll very briefly give you a sort of two-step approach. Number one, a party challenging a law on equal protection grounds that looks race neutral needs to prove there's a substantial disproportionate racial impact. If the challenger can prove that, I would suggest the challenger wins unless the lawmaker can carry the burden of proving either that the law bears a substantial relationship to an important interest, or the lawmaker can prove that at the time of adopting the law, the lawmakers did not foresee and with due diligence could not reasonably have foreseen that it would have a substantial disproportionate racial impact. So what implications does this have for today's legal barriers to voting? In Washington against Davis, at the end of his discussion, Justice White wrote for the court. He said, "A rule that a statute designed to serve neutral ends is nevertheless invalid unless necessary to a compelling interest if it in practice benefits or burdens one race more than another. Such a rule would be far-reaching, would raise serious questions, and perhaps invalidate a whole range of tax, welfare, public service, regulatory, and licensing statutes that may be more burdensome to the poor and to the average black than to the affluent white." That statement that Justice White made at the end of his opinion was basically irrelevant in the case because it addressed the implications of applying a standard of review that actually nobody was arguing for. The argument there was much more for a middle tier type of approach. There's no reason to see my approach, which takes this sort of middle tier standard, as the kind of engine of destruction that Justice White describes. On the contrary, you would assume that if a challenger can prove that a law has a disproportionate racial impact, the government often will be able to defend the law successfully by demonstrating that impact was unforeseeable or the law meets a middle tier standard. The punchline for voting rights is that's not going to be true with the kind of laws that we see that have a disproportionate racial impact in the voting areas. These are laws that when you look at their justification, it barely meets what you would call rational basis scrutiny. The justification that's always put forward for these kind of laws is fraud. And as the Commission on Civil Rights found, they said the prominent argument championed by supporters of voting rights, of voter ID laws and similar measures is that they prevent voter fraud. And the court and the Commission basically says there's simply just scant proof and often non-existent proof that such fraud exists. So an approach, I think a realistic approach to Washington against Davis and Arlington Heights to the problem that they raise and I think wrongly try to solve, a realistic approach I think really has revolutionary effects for laws that disproportionately affect racial minorities in voting. Finally, I just want to underline, I'm well aware today's Supreme Court is not the first group I would want to choose to be doing something adventurous in this area. After the Shelby County case, is this the right audience? Well, what I would underline is at least make the argument to the federal courts today, but keep in mind state constitutions. State courts have authority. They're the ultimate authority on the meaning of their state constitutions. There are equality clauses in the state constitution, and that's where these arguments can be made, I think, at least today, more successfully than the Supreme Court. Thank you.
Thank you, Gary. And our third speaker is Michael Kang. Michael Kang is the William G. and Virginia K. Carnes Research Professor at Northwestern Pritzker School of Law and nationally recognized expert on campaign finance, voting rights, redistricting, judicial elections, and corporate governance. Professor Kang received his BA and JD from the University of Chicago, where he served as technical editor of the Law Review and graduated Order of the Coif. He also received a PhD in government from Harvard University and an MA from the University of Illinois. And the most important thing is that for a long time, Michael Kang was my colleague here at Emory Law School, but sadly left us to go to Northwestern. But nonetheless, we have him back, and he is going to talk to us about polarization.
Thanks, Sasha, and thanks to ELJ and Will and everyone for putting together this conference. As Sasha mentioned, I spent a long time here, the first 14 years of my career, and excited to be back, see old friends, make new friends. I apologize for bringing some of the Chicago weather with me to Atlanta. I was hoping for a nice sunny Atlanta day, but alas, no. So what I want to do is talk a little bit about voting rights law today in a historical context, and I think this connects up a little bit with what Andrea spoke about. And I want to argue that voting rights law today operates in quite a different political context than it did when election law really began about 60 years ago, around the civil rights movement. And I think this matters quite a bit. The political context has really shifted from one that's predominantly racial, where party really wasn't as salient as it is today, and partisanship wasn't nearly as high, to the emergence of modern hyperpartisanship, or hyperpolarization, however you want to think about it, that affects really, I think, every aspect of voting rights law now. And by hyperpartisanship, I don't mean anything particularly technical in the Abbey Wood sense. I just mean two parties that are very different ideologically, that are bitterly opposed and trying to really compete and hurt each other in the spirit of that competition. So I want to, I think, leave you with at least two takeaways. One is that this shift from an era where voting rights law didn't really grapple much with partisanship, and partisanship was fairly low, meant that our inherited voting rights law doesn't grapple very well with the kind of partisanship we see today as a kind of major state motivation for the making of election law and today's kind of blood sport partisanship. And the second thing is that I want to kind of highlight the fact that for a lot of us, and I think especially for people at least my age or older, it's hard to see that while we think of today's hyperpartisanship as fairly extreme and unusual, I would argue that it is pretty extreme, but not that unusual, historically speaking, in American history. We're used to this because our norms were from the Cold War, where partisanship was relatively low by historical standards, but that's not that normal for American history. And what I think that means is the kind of hyperpartisanship we see today is not likely to disappear soon. It's not just some weird symptom of a few different political personalities or something that's going on now but not going to continue in 30 years. And what that means is the mismatch or blind spot to partisanship that we have in voting rights law today I think is a deep problem to what's, I think, is a kind of enduring problem in American politics, and that we have to sort of think about this not as a temporary problem, but a really deep and potentially permanent one. Okay, so first, the history of voting rights law. Some of you may know this, some of you may not. So 60 years ago, election law was really just beginning as a cognizable subfield of constitutional law. Before the 1960s, I think it's fair to say that election law really didn't exist in the way we think of it today. We certainly wouldn't have a class that, that I teach or Richard or Abby teach at their schools. Courts generally abstained from election-related cases out of broad deference to the political branches of government. So they generally stayed out of election law. It wasn't really till the 1960s that courts finally dove in to election law in the malapportionment cases, one person, one vote. And it's really these historic cases like Reynolds versus Sims and Gray versus Saunders that Emmett Bondurant helped litigate that initiated this kind of regular judicial intervention into election law that we're familiar with now. So during that period, early 60s, you have the one person, one vote cases that kind of kicks things off. You get the Voting Rights Act in 1965 that required courts to address questions of election process and structure. And then all of this activity along equal protection grounds spread to election administration, where courts started looking at franchise restrictions and pressing jurisdictions to expand the vote or extend the vote. And then not too much longer after that, Congress passes major kind of comprehensive federal campaign finance regulation during the early 70s, which brought the courts into making the constitutional law of campaign finance. And the funny thing about this history is that it's happening in the 60s and 70s, exactly when partisanship happened to be about as low as it's ever been in American history. And so if you think back to the 1960s, what's going on in politics in America? It's really race, not partisanship. That was kind of the defining problem and divide in American politics, and certainly in election law specifically. You had regional tensions that predominated. It wasn't so much a national cohesive Republican Party versus a national cohesive Democratic Party. There's a lot of regional factionalization, and the parties were largely local and regional, and there wasn't a lot that defined the national parties cohesively across state lines or across regions. You had a lot of urban, rural rivalries that cross-cut the parties. And so election laws created during this weird moment in American history that I'll talk about more, this bipartisan moment where partisanship really didn't present its normal complications, and certainly not the kind of complications we have today. So one way to illustrate this is to think about one person, one vote, these cases that kind of kick off election law. So malapportionment was a big problem in the middle of the 20th century. You had the most populous districts in Alabama, for instance, in Reynolds versus Sims, that was 41 times larger in terms of population than the smallest districts. The urban ones really densely populated, way bigger in terms of population than the smallest ones, the rural ones that were fairly underpopulated. This has a massive effect in terms of overrepresenting rural areas. You would think, with today's political lens, that really benefited the Republican Party, because we think of the Republican Party as the rural party. We think of the Democratic Party as the party of the cities. So you'd think it would have this big skew in favor of the Republicans, but that's not how politics were at the time. So the average partisan bias from this huge problem of malapportionment was effectively zero nationally. And why is that? Well, it actually helped Republicans in some states and it helped Democrats in others, because neither party was clearly defined nationally as the party of the city or the party of the country, the way that we think of the parties today. So it helped Republicans in some states, helped Democrats in other states, but it overall canceled out. And then there was a huge part of the country where we are now in the South, where malapportionment didn't matter for the partisan balance of power, because they were all Democrats, right? So it didn't matter. You had different kinds of Democrats maybe, but it wasn't swinging control from Republicans to Democrats. So you have basically, before one person, one vote, those cases, you have a partisan bias of effectively zero. And And then you have this massive intervention by the courts to effectively redraw all the congressional districts and basically like all the state districts, the state legislative districts. And you would think that that would have a big impact. Well, guess what? Afterward, the partisan bias nationally is zero. Why? Because it's just canceling out all these advantages. So the states where malapportionment helped Republicans, well, they've lost that advantage. Democrats benefit. But then there's other states where Democrats benefit from malapportionment. And one person, one vote takes away those benefits and gives it to the Republicans, so it all washes out. Now, think about that today. Any sort of major election law change like this, I mean, you think about the Electoral College, everything we view through a partisan lens, whether it helps your side, whether it hurts the other side, does it swing power from the Republicans and Democrats? And chances are that it would. But in the 60s, it didn't. The partisanship just wasn't nearly as salient. This helps explain why the one-person, one-vote cases, generally speaking, the Republicans and the Democrats were both kind of generally okay with it. It really didn't have a big partisan swing associated with it. It's kind of unimaginable today that we would have some major transformation of election law and that the parties wouldn't see some sort of partisan advantage from it and that it actually wouldn't grant some sort of partisan advantage one way or the other. Everything has a partisan valence today. And so we forget, I think, sometimes how unusual this Cold War period was. That partisanship was just really not that salient. And I think, again, for people my age or older for sure, we tend to think of that Cold War period as normal, as the kind of normal time where people were sane and you could cut bipartisan deals, and today's the weird period. But actually, if you look at American history, it's closer to the other way around, that period was weird, and actually most of American history has been characterized by this hyper-partisanship where two sides are going at it. If you think back to the founding, and if you haven't seen Hamilton, I'd recommend it. My daughter loves the music and the characters and stuff, but as an election law person, a weird election law person, I just see partisanship. I think, wow, that looks a lot like today. You have two parties that are just going at it like crazy and using all available means to try to win, to beat the other side. That looks pretty familiar. So the founders, for all of their antipathy for factions, immediately broke into parties, fiercely opposed parties at the time of the ratification debates. That really continues through the 19th century. So I have a separate paper that's really dealing with gerrymandering and looks at the history of gerrymandering during the 19th century. And what you see is the gerrymandering practices of that time were very much like today. There was a lot of repeat redistrictings. They were trying to gerrymander the other side all the time at basically every level. They weren't as good at it as we are today, but it wasn't for lack of trying. They were really trying really hard to gain partisan advantage through the redistricting process. But what starts to happen during the middle 20th century is that partisanship starts to wane, and the parties aren't really defined very much ideologically. If you think about a Democrat and Republican in 1950, for instance, and you found out someone was a Republican, you wouldn't actually know that much about their policy views. To the degree they had, it wasn't that the Republicans were uniformly conservative. It wasn't that Democrats were uniformly democratic. You might have, an urban city Democrat who's pretty conservative, or you might have a Dixiecrat who is really conservative, and then you might have a liberal Democrat from the Northeast or somewhere else. You really couldn't tell a lot from the party label the way that today we can. And one way, I think the best way to show that is just a couple slides. So one is, this is the ideological distance between the two parties in Congress. And you can see it starts out in 1878, that's the late 19th century, and then this continues into the 21st century. Well, the ideological distance is pretty high until starting in the middle of the 20th century, and then it drops off dramatically, meaning the two parties weren't that distant. They started to converge. And they weren't as defined ideologically. Now, preview ahead, it starts to spike after the end of the Cold War. There's a lot of reasons why one might guess the Cold War was a little different. That's not really the subject of what I'm talking about, but it was. It was quite different in terms of the ideological character of the parties. And then this is just another way of illustrating the same thing. This is the ideological overlap of the two parties in the Senate. And so what you see is, it looks like there's no data until like the 1920s, but that's actually a flat line. There is no ideological overlap between the two parties in the Senate until the mid-20th century. And then you see all the lines starting to go up. Those are just various ways of representing the ideological overlap of the two parties, meaning that the parties started to overlap, right, in Congress, and then again it dies off after the Cold War. And again, at the end, it's all flat because there's no ideological overlap today. So this Cold War period is really unusual. And if you think to, let's say, the early 60s, time of the one-person, one-vote cases, Baker versus Carr, about a quarter of the Senate overlapped ideologically from one party to the other, meaning the most conservative Democrats were more conservative than the most liberal Republicans. And it's a lot easier to have bipartisanship and cut cross-party deals when ideology means a lot less and you have a lot of shared views. And election law is being created during this period. And because of that, the election law that's created kind of has a blind spot to the kind of partisanship that actually is fairly normal in American politics. So what do we have today? So today, hyperpartisanship is back. There's no longer any ideological overlap in Congress or really anywhere. And the ideological distance between the parties is actually higher now than it's been. And there's a lot of partisan animus. Another way of sort of thinking about this, we don't have data on this like back into the 19th century, but it's useful to remember that about a third to half of Democrats and Republicans at the voter level feel the opposing party is so misguided that it threatens the nation's well-being. And roughly half of partisans from both sides report being fearful of the other side. If you look at views on impeachment, they're just mirror images of each other, right? Republicans and Democrats can't seem to agree on things. This is kind of a fun stat. About half of Republicans would be upset at the idea of their children marrying a Democrat. It's a little less for Democrats, it's about a third, but those are pretty high levels. And what is interesting about that is this and the same question for race, it's kind of flip-flopped. So if you looked at this question in the 50s and 60s, people actually don't really care if their kids marry someone from the other party. Just it's not something that people think about or are worried about. But they are actually upset about the idea of their child marrying someone from another race. Today, it's kind of flip-flop. Both questions are flip-flop. People are worried about their kid marrying someone of the other party, but at least they report a lot less anxiety about their child marrying someone of a different race. Right? And so partisan has really gained a lot of salience over this period for all the reasons that I've mentioned. So it's not surprising today that election law is now deeply wound up with modern partisanship and the really different partisan incentives than we had during the Cold War. And so I've done a lot of work on gerrymandering and sort of trace this through, but today we're talking about voting rights, so let me do that a bit. So I think maybe Richard and Andrea and Gary, everyone sort of mentioned at some point government issue, the requirement of a government-issued photo ID for voting. So this is a law that is obviously in the news a lot and we're thinking a lot about in this area. They really weren't around during the Cold War. There weren't these ID requirements during the Cold War. In 1980, by my count, about 5 states required or even requested any voter ID, not let alone required. So it wasn't common at all. By 2000, this number nudges up a little bit to about 14. It's a mix of Republican and Democratic states, but it's really in the 2000s where this becomes entirely partisan. Georgia is kind of a leader in this area, and so there was a highly litigated photo ID requirement here for voting. It actually got struck down at the district court level the first time, but eventually went through. And these stricter requirements for photo ID really started to spread in the 2000s through today. Today, about 35 states have some sort of ID requirement, but about half of those are photo ID requirements, and those are almost exclusively in Republican-controlled states. So you have a similar pattern that I think Richard mentioned for early voting, where it didn't seem these kinds of requirements, to the degree that they existed, they didn't follow a partisan pattern until the 2000s, and then everything switched and kind of splits along partisan lines. And so why do we have these laws? Well, the articulated, I think Gary mentioned this, the articulated state interest for this is the prevention of in-person voter fraud. You force people to show an ID because it proves that they're the person they claim to be, and then that person is allowed to vote, but you can't pretend to be someone else because you won't look like the picture, because it's just so hard to fake that. Now, I believe that there are some legislators who think that voter impersonation is a big problem. Like, I've talked to enough that I think there are people who really think this, and that you need to have these voter ID requirements to stop it. But I think Gary mentioned this. There's basically no credible evidence that this is a real problem, that it happens with any sort of consequence. There is voter fraud that we should care about, but it's not in-person voter impersonation. It's just a really dumb way to do it. If you're going to do it, don't do it this way. There are better ways to do it, like absentee balloting and stuff. But this is not really a problem. But we have a lot of reasons to think that voter ID requirements, the photo ID requirements, discourage voting by certain groups that tend to vote more Democratic than Republican, and the states that have passed the stricter photo ID requirements are almost exclusively Republican controlled. So this is not a coincidence, and this explains why Judge Posner, a Republican appointee, switched positions on voter ID. Initially in Crawford, the big Supreme Court case, he upheld the requirement, and he said, like, the fact that this benefits Republicans and hurts Democrats, Posner says, this is legally insignificant in this case. It's just not, it's not something that equal protection cares about. But after 6 years of seeing these laws passed only in Republican states, without any sort of substantiation of the state interest here, Posner switched and no longer supported or no longer willing to uphold these voter ID laws, and said there's only one motivation for this. It's partisan. So why do we see these kinds of moves with hyperpartisanship? Well, I think at least three kind of general reasons. One is hyperpartisanship means the desire for partisan advantage is greater than ever. There's just more people who want to hurt the other side and advantage themselves through election law than ever. There's just greater intensity along partisan lines. Two, it's also easier to do. It's easier to game election law when voting is so predictable and polarized along demographic lines. So the example mentioned earlier about accepting voter IDs when they're a hunting license but not student IDs, well, in the 50s and 60s, I'm not sure that would have been that predictive of a Democratic or Republican vote. But today it is, because the parties are so split in fairly clear ways along demographic lines. And so it becomes easier to game these election laws when you kind of have a much better sense of how people are going to vote. And then third, party competition is more intense than ever, and the spread between the parties is greater. So if you think about this, this is effectively the payoff from your party winning instead of the other party winning. And so if you can swing through election law, the election to your side, so you win and they lose, well, the distance is a measure of like how big a gain you're going to get in terms of policy. Like, you're winning the seat instead of someone else. Well, that represents, as the parties get further apart, the payoff from playing these games is bigger because the parties are further apart. Now, I don't need you to buy Posner's story or my account of voter ID laws. The really more important thing is that there's really very little, I think, right now as a doctrinal matter to prevent governments from playing these partisan games, from structuring election rules to favor the majority party, as long as they kind of claim some make-weight government interest as a cover story. The courts have not as much doctrinal leverage to do anything about this because the genesis of election law all occurred during this period where partisanship was low. And if you look at those cases, partisanship just isn't present. So it's not something that election law accounted for or had to deal with in its making. It's just not designed to deal with the problem of partisan manipulation. The gerrymandering cases are like a great example of this. That's exactly the question the Supreme Court was thinking about in the gerrymandering cases, in Rucho and Whitford. It's, are you going to do anything about the state taking a side in the party fight and gearing the election law to benefit one side over the other, just partisan discrimination. And the court there, the Supreme Court ultimately, as you know, threw up its hands and said, this is not what equal protection ultimately is about. We've never done anything about this, and we're not going to do anything now. Right? It's an example of how partisanship just isn't present in the law. Now, when courts are presented with cases of, let's say, voter ID or election administration rules as violations of the Voting Rights Act or along race grounds, it's a little bit of a different story. The courts are much more receptive of those arguments. They have less trouble striking down those laws because that was actually what election law was about in the making. So election law knows how to deal with those problems. The partisan discrimination point is not, it's just not there in the law right now. My view, and Emmett Bondurant's view, and many others, is that there's a lot of constitutional law that would support the argument that partisan discrimination should be unconstitutional, that it is a problem, it's something courts ought to deal with. But that law is largely outside of election law. So if we look only inside election law has been filtered through this the racial lens and not at all a partisan one. And inside election law, there's not a lot of doctrine that supports courts striking down partisan overreach. And so the courts have this kind of blind spot to overweening partisanship as a basis for election lawmaking that's really hard to overcome, I think. And today, it's sort of overcome by the kind of partisanship that one might want to check, in the sense that even a move by the courts to try to curb partisanship is itself going to be seen as a partisan move, right? So if the courts had struck down, had decided to put some sort of equal protection constraint on gerrymandering, or First Amendment constraint on gerrymandering, it would have been seen as a move that helps Democrats and hurts Republicans. And of course, the decision not to do anything is definitely seen as a move that helps Republicans. Often, I think, it's seen as a move to help Republicans by Republican judges. So it's very hard for courts to get out of this now that that's already built into the law, to the degree that we think of these as partisan questions and they're governed by judges that we think of as partisan. It's not clear how we're going to get out of that trap. But partisanship is not going to go away. It looks like something that is an enduring feature of election law, and this blind spot problem is not a temporary one. It's, I think, a really serious one. Thanks. Can I read this up?
Sure. Thank you, Michael. And so I want to get the chance for questions from the audience. So we have our mics. So if you want to line up by the mics on either side. So just when you ask your question, could you say your name, your affiliation if it's relevant, and if you want to ask the question aimed at one or several of the panelists, just say that when you ask your question.
Hi, I have to kind of stand up a little higher to get this.
You could rotate the mic down.
Oh, wow. Okay, so hi, I'm Tallulah Lanier. I'm a staff member at ELJ. I'm a 2L. I have a question for Professor Simpson. In your two-part test, you mentioned the second subpart being about when the law was enacted that it couldn't have been foreseen to have a disproportionate racial impact. When we think about that, I think about kind of the issue of implicit bias in that maybe at the time someone didn't realize that that could be the case, but with a changing racial, ethnic, and cultural landscape, that still becomes a problem. Do you see that law being struck down on another ground, or do you see another way for that to be challenged outside of the disproportionate impact test?
Well, I guess there's another line of decisions. I mean, I think the decisions like the Crawford case, I look at that as wrongly decided too. And I think that is probably the vehicle for getting at laws that sort of meet the description you described.
Hi, my name is Suman Malampati. I'm a 2L student and ELJ member as well. And I apologize, this is kind of a comment on question rather than a specific question, but tying all of the three talks together, we've talked about partisan gerrymandering and partisan laws, but I wonder if you could comment on now it appears that partisan really has a racial tone to it. So for example, I just saw a statistic the other day that 100% of Georgia's state House representatives are Republicans are white, whereas only 29% of Democrats in the Georgia House are white. And you see something very similar, in the US House and Senate, and you see that among voters. And so while, in the Professor Kang in the 60s, this was really about race, and now it seems to be more about, partisanship and, the divide there. It seems like partisanship in some ways may be sort of a, pretense for race. I was wondering if the three of you could comment on that.
So that's, I think that's a perfect question. I don't know if you all caught that my dad was registering voters for Eisenhower, right, in the 50s. And so what we saw and what Lyndon Johnson said when he signed the Civil Rights Act is that, Southern white people are going to leave the Democratic Party, and that's what happened. I think our current governors, our previous two Republican governors started out as Democrats. And I think one of the things along with, one of the other sort of psychological predictors of whether you're a Republican or a Democrat is also your racial resentment score. And so there is very much an overlay, of race in the partisanship. And I think that's one of the things that, election law does allow us to get at the race aspect of partisanship. It makes it more difficult, but you're absolutely right. I mean, the division that happened after the Civil Rights Movement, was Dixiecrats leaving the Democratic Party and becoming Republicans. The Southern strategy of Nixon, attracting those voters, and so you have. Richard Shelby, who used to be a Democrat, Strom Thurmond used to be a Democrat. I mean, that the racists in the Democratic Party left and became Republicans. Now, what you think of that is up to you, but they seem to feel welcome there.
So, just to be clear, I don't mean to say that race isn't a problem. And I think you're right that the partisan divide is, in an important way, a racial one, too. Now, there's a whole debate about what does it mean for it to be based on race instead of party. I'm not that interested in really trying to sort that out to the degree it can be sorted out. What I would say is it's actually worse now. So to the degree that there's an overlay between race and party, it just increases the motivation to discriminate. It makes it worse. And then in addition, I think it makes it easier to mask racial discrimination. So one of the things that you see in the Shaw cases, a whole line of cases about racial gerrymandering, is that the argument often made by the state is, well, we're not actually discriminating based on race, we're just doing it based on party. And the thing is, to the degree that election law is really aimed at racial discrimination and not the party discrimination, well, you can kind of get away with it, right? So that's a problem. I think both are bad, but the law really only addresses one part of that piece. So in my view, normatively speaking, I would say the law would be better if it addressed both, because it's hard to distinguish those. It's not clear exactly what it means for you to discriminate against African Americans as African Americans instead of as Democrats. It seems like either way, it's the same problem. I mean, I can get the idea that the animus part of things, but that to me is not an important legal distinction. We ought to, I think equal protection would really be served by having courts intervene against both types, regardless how it's framed. And so I don't mean to say race is not important or salient, but I think the partisan piece of things has changed, and I think that's very important.
I don't have anything to add. Thank you.
All right. The gentleman over here.
Two anecdotes about Georgia elections and then an observation. I had a friend who was, when he was at college at Emory 50 years ago, was attached to the Herman Talmadge campaign as part of his political science program. So he went someplace in rural Georgia, and as he's finishing, the clerk says, don't forget to have the campaign call us up to tell us how many ballots we have to put in the box to make sure Mr. Talmadge wins. Then my mentor, when I was starting to practice law, was trying to get African Americans to vote. So they sent a professor to go register to vote. And he goes to register to vote, and he comes back. He said, they had a reading test. And he's, oh, yes, you passed that? He says, no, it was in Chinese. The observation is that I'd like you to comment. I used to represent labor unions, and it occurs to me that a lot of the program today, Mr. Bondurant and you folks, it's the establishment putting pressure to make the lesser stay lesser. Over with labor unions now, that's what's going on in the legal system. 2018, the Supreme Court decided a case named Janus, which stopped public employee unions to make members pay dues. And about 4 years ago, when I worked in DC, I went to watch 6 years ago, I went to watch a Supreme Court argument. And John Roberts yelled at a Teamsters lawyer for making a fairly innocuous argument. And again, it's pressing the lessers down. I'm just curious about your observation of that.
Well, my response would be more of a political response than a legal response. I mean, I think that that it, you know, to the extent that there is something that, to the extent that we saw a partisan divide where Democrats were more the party of labor and Republicans were more the party of corporate, I think some of that has also been. I mean, I happen to know I mean, Clinton made this sort of unholy alliance with Wall Street. So I think we have seen that, I think, you know, the Democratic Party has failed in its responsibility to labor. And I think, you know, maybe 2016 was one of the, you know, ways of paying the price for that. But I think we really are not articulating enough, and in, I mean, in our civil rights law, we really don't have a way to talk about the poor, right? Just like we don't have a way to address partisan issues, we really don't have the tools for addressing, you know, the poor and working class and things that are making life more difficult for that, you know, majority of Americans. So I think that's it's more of a political issue. If I had been President Obama and had, you know, had the House and the Senate, I would have done a lot of stuff to really make it easier to be in a union and for unions to have power. That's what I would have done.
All right, we have time for one more question.
Thank you. My name is Sarah Tyndall-Gazelle, and I'm an Emory alum. In fact, was the symposium director many years ago. So, and from that, and this is the perfect graphic to have up here, what's old is new again. I was recently a complainant before the state election board in Georgia over a case where Klan paraphernalia was found on an early voting election site, and the case was dismissed. They tried to dismiss it early without really any investigation, not even calling the phone number that was on the pamphlet that was sent back. But again, it was dismissed, and the only comment that was made by the state election board was by the Democratic member on that. In December, the RNC was taken out from under a 30-year consent decree for having their poll monitors outside. In other words, armed, off-duty police officers and others standing outside polls and sending threatening letters to voters saying, threatening to arrest them, basically. We've seen that in Hancock County, where it has required DOJ supervision, because again, this is happening over and over again. Now, it's going to be supercharged without this consent decree. Litigation by its nature is reactive. How do we use the tools at our disposal to be proactive and stop this from happening? as opposed to, once again, litigating after the fact when the results are already in. And I send that to the whole panel.
So that's what Section 5 used to be about. And so Sarah was one of my first students at Emory, and that was back when there was Section 5, and we spent a bunch of time on it, and that's exactly how I explained it, because it's really hard after the fact to bring litigation, and it's expensive, and it's hard to put out all those fires. And so Section 5 served a really important purpose, and we no longer have it. So I guess my answer would be to have something like Section 5 again, to pass legislation and hopefully have it be upheld by the Supreme Court. But that's a pretty big lift.
One of the things we're doing is, particularly after the experiences of 2000 leading up to 2018, is we have about 20 of the larger counties in Georgia where we're monitoring the election boards, having a team of volunteers that always goes consistently and reports back and monitors the kinds of decisions that are being made. We'll be doing a survey, say for disability access of polling places. So we're trying to be proactive in a very granular way, and then back that up, with litigation as necessary. But one of the things I failed to point out, without Section 5, Brian's case in America took 6 years to resolution. And so it's extremely costly to litigate after the fact. You're absolutely right.
All right, well, thank you very much, Andrea Young, Gary Simpson, Michael Kang. Thank you for coming to listen to us.